Patterson here on behalf of the Crown. Mr. Gauthier is present. This is a matter that I had inherited from a colleague. It's still relatively new to me. Mr. Gauthier had retained Mr. Roy to assist him with the sentencing, although that was a short-lived relationship. Mr. Gauthier advises me this morning that he wants to proceed, which I'm in the court's hands with. I just need a little bit of time to organize my thoughts before we proceed to the sentencing.
I see. Mr. Gauthier, does the Crown, I mean, there was a report prepared that I've received. Have you seen that report?
I'm just going through it right now.
Okay. Mr. Gauthier, have you been provided with a copy of the report?
No, sir.
Okay. Let's get you a copy of it. I'm going to stand down, but I'll make sure that you get a copy of it so that you can read it prior to anything more being done on this matter. I'm going to give the Crown some time to look at it. If you want, after reading it, think about things and want to talk to a lawyer about it, I'll certainly give you time to do that. If you're insisting on the matter proceeding today, I'll hear from Crown Counsel whether they feel they're in a position to do so. But I won't do that right now. I want to give you each some time to look at this report, okay?
I was under the impression that today was for sentencing, though.
It is.
Okay.
And I'm not trying to delay it.
This gentleman was just not prepared?
No, it's not that he's not prepared. He needs a little bit of time in order to
Did he not write
prepare.
the report?
Don't interrupt.
Oh, I'm sorry.
Don't interrupt.
Just a bunch of thoughts were going.
Don't interrupt.
Sorry.
He needs a little bit of time to consider his position, and I want to give you, because I want to make sure that you know exactly what the Crown is saying, what I'm looking at, give you time to look at the material as well.
I appreciate that.
Understand that?
Yes, sir.
All right.
So he didn't write the report, though?
No, he's in the process of reading the report, okay? I'm going to give you a copy of the report.
The report is from forensics.
Correct.
Got it.
All right. So just stand by. I don't know, are you able to produce a copy here? Or
I'm new to this whole process,
I
sorry.
understand. I've got a copy. I want to make sure that I didn't put any notes or anything on it. I don't think I did. No, I didn't. Pass that copy to Mr. Gauthier.
Yes, Your Honor, for Mr. Gauthier's benefit, I will be ready to proceed today if we proceed.
All right, so we're going to stand the matter down, Mr. Gauthier. I have some other matters on the list.
Okay.
Read the report over.
This is the one that's not done yet?
No, it appears to be completed to me.
Oh.
So just spend some time looking at it. If there's things about it that you're not certain about, you can raise that with me when we recall your matter, okay? But just take some time to look at it, all right?
Thank you.
All right.
Thank you, Your Honor.
Number 4, Renee Gauthier.
Yes, Your Honor, Judge Patterson here on behalf of the Crown.
Mr. Gauthier, just come forward. Your person, Renee Roger Joseph Gauthier.
Yes, sir.
And Mr. Gauthier, you're appearing today without a lawyer assisting you, is that correct?
Correct.
And do you wish time to speak to a lawyer before proceeding any further today?
No, I've consulted with my assistant today.
Okay, I'm not sure who or what your assistant is, but I can give you an opportunity to speak to a lawyer before proceeding any further. If you wish.
I really appreciate that. I think we're good to move forward, sir.
Sorry, we're good, and I didn't quite hear what else you said.
Oh, I appreciate that opportunity, and I would like to move forward.
Okay, does that mean you're wishing to proceed with the sentencing hearing today?
Yes, sir.
It does, okay. Without the benefit of any legal assistance from a lawyer?
Correct.
All right. Okay, I've also been provided with an assessment that was conducted by a psychologist, I believe. Just check the qualifications of this person. psychiatric services, so I believe this is a psychologist?
I believe it's a psychologist.
Yes. So we'll call it a psychological assessment. I gave you a copy of it, Mr. Gauthier. Have you had a chance to review it?
All 11 pages, yes, sir.
Okay. And do you require any additional time to consider any of the contents?
I'm open to discuss what I've read.
Okay, well, I'll hear from you, but I think what I'll do at this point, Mr. Gauthier, is just hear from Crown Counsel firstly about what position they are taking on the sentencing, and then I'll turn again to you and ask you whether you need some time to reflect, okay?
Sounds good.
All right, Mr. Paxton.
Yes, Your Honor. Thank you. Thank you for the time. The Crown's respectfully submitting that an appropriate sentence for Mr. Gauthier is that a conditional discharge would be appropriate. The psychological assessment indicates that he's at a low risk to reoffend. His bail supervisors advised me that he's reported properly over the last year. There's been no alleged bail breaches. So the Crown's position is that a conditional discharge would be appropriate. In the Crown's respectful submission, probation order in the range of 18 months would be an appropriate length. The conditions the Crown is seeking is a reporting condition, a residency condition, no, and counseling as directed by the probation officer, including forensic counseling. And I think, Your Honor, once Mr. Gauthier has completed that counseling to the satisfaction of forensics or the probation officer, that the reporting condition can be terminated at that point.
Is the Crown seeking any kind of weapons prohibition? Probation order?
No, Your Honor.
Okay. And just before I turn to Mr. Gauthier, the ancillary orders if possible, no discretionary firearms prohibition, and Crown is not seeking any order that he provide a sample of his DNA for entry into the National DNA Database.
That's correct, Your Honor.
Okay. All right, Mr. Gauthier. I'm not certain if you understand the Crown's position, but I'll spend a bit of time explaining it to you.
Okay.
The Crown is asking me to consider what is called a conditional discharge. And a conditional discharge would ultimately result if you comply with the terms of a probation order, the terms of which the Crown has set out, and I'll go into those in a bit more detail. If you comply with the terms of that order, it would result in the end in you being discharged absolutely from the offense, meaning that you'd be left with no criminal record. Okay? The Crown takes that position because the report that was prepared in this instance indicates that you were at low risk to reoffend, and the fact that you don't have any prior criminal record. Okay? In addition to that, you've been, as far as Crown knows, compliant with bail conditions that have been placed on you up to this point. And so, with all of that, the Crown is saying that it would be in your best interest to receive a discharge, and not, in all of these circumstances, contrary to the public interest. Okay? The terms of the probation order that the Crown is seeking, firstly, that they're asking that you be subject to an 18-month period of supervision. There are statutory terms that would be required for me to impose, which are very basic. They require that you keep the peace and be of good behavior and report to the court when you're required to do so. And when I say statutory terms, those I don't have any discretion over. Okay? Those the criminal code requires me to impose in the event that I impose a period of probation. In addition to that, the discretionary terms, so meaning that I can decide their appropriateness, are that you report to a probation officer, similar to, I think you've been required to report to a bail supervisor, probably be basically the same person, same location. that you provide information about where you're living and how to contact you when you first report, and inform them if you change those locations or numbers. That you have no counseling at the direction of your probation officer, which can include forensic outpatient services. Okay, and that would be the only terms that the Crown is seeking in this probation order. Upon conclusion of any counseling that you may be directed, I would include a term in the probation order that your probation officer has the discretion to direct that you no longer have to report to that person. Okay. Now, I don't have to impose those conditions, but I will say to me, the Crown is taking a very reasonable position in all of the circumstances that I'm aware of, and they do not appear to me to be overly onerous, and I think that they may also serve to benefit you, help you in certain ways as well. Okay, it doesn't mean that I want to see you get certain help and that I need to know that it is taking place, but these are basic requirements, and if you comply with the terms of that order and you do so in a timely way, very likely the probation officer will no longer require you to report, but you have to wait until you're told that. Okay, I've had an opportunity to review the psychological assessment. I'm aware of your background. Ordinarily, I find out details about your background from either you directly or from a lawyer who's representing you. But I can see generally from what has been written that you've had a pretty difficult background in many ways. Okay, and despite the difficulties that you may have experienced from a very early age, you managed to stay out of trouble, okay, until this event, and I'm aware of all of that. But there is concerning behavior which I found to be criminal, and it has resulted in a conviction being recorded against you. But in this instance, if I agree to do what the prosecutor is asking me to do, and you complete the probation order without difficulty, it would result in no record being recorded against you. It would be discharged absolutely from the offense. So, is there anything you want to tell me about all of this? I'll give you a chance, but I'll tell you this. The most important thing that I've seen in that report is that you're assessed at low risk to reoffend. Okay? All right? So, is there anything you want me to know about any of this?
Yep. This is my time to.
This is your time.
To blast your ear off.
To which?
To like blast your ear off, like give you like a full like jargon of everything that like I wrote down preparing for this.
I'll give you a chance. I may want you to cut things a little bit shorter depending on what I hear, but I'll give you a chance.
Okay. Well, first off, no matter what happens, I'm happy that we're proceeding and that the conviction is taking place today, because here is an appeal that I'm going to pursue anyways. I know that you, near the last bit of everything that you said, you mentioned like my past and this and that, which is a really complex situation. But yeah, so moving forward, the evaluation to understand my mental health. So this like 11-page report was aimed to understand my mental health, risk of reoffending, and the treatment needs. I know you already kind of mentioned some of this. My risk for intimate partner violence is considered low. The primary concerns are related to my mental health, particularly my quote-unquote paranoia, which is more general than specific to IPV. That being said, I'm in the process of filing 4 complaints with the College of Physicians and Surgeons of BC, and another with the West Shore RCMP regarding the false diagnosis, medical malpractice, and corruption. So, the last bit of what you said of my complex situation, that it is very complex, and I'm climbing climbing this steep hill. So that being said, my strengths: first-time offender with no prior criminal history. Ability to maintain employment in the past, engaging mental health support, like I'm currently working with the CARES clinic and seeing psychiatry. So for a positive resolution for my complex situation. Sober for over a year. I've been on probation for over a year already with 0 issues, which you already stated.
Been on bail supervision.
Oh, so
it may seem like probation, but it's actually bail supervision.
Sorry for
No, you don't need to apologize. I know it may not seem.
That's what I
there's a
meant.
difference. There is a difference.
Okay.
And the difference is that while subject to bail supervision, you were not considered guilty of any crime. Post conviction, you get placed on probation, not bail supervision. Okay, so there's a distinction between the terminology, and it may be a different person that you're subject to. There's some other technical differences, but it is probation. Okay, at this point, we're previously on bail supervision.
Thank you for making me understand. I have demonstrated a significant personal growth and commitment to rehabilitation by engaging with mental health support services as outlined in the forensics assessment. As a first-time offender with no prior criminal history, I believe an absolute discharge is appropriate, reflecting my low risk of reoffending, the minor nature of the offense, and the proactive steps towards managing my mental health issues to ensure such incidents do not reoccur. An absolute discharge would allow me to move forward without the stigma of a criminal record, plus the offense for which I'm convicted of was at the lower end of the spectrum in terms of severity. An absolute discharge would be proportionate to the nature of the offense, especially since I did not involve violence or significant harm. Conditional discharge would affect employment opportunities, travel, and social standing, which would hinder my rehabilitation and reintegration into society. That's all I got.
All right. Well, Mr. Gochi, I can tell you in no way did you blast my ear off, and the things that you said were respectful and also appropriate. They were an appropriate response to the Crown's submissions. I will say, however, that I regard your conduct, as I found it in the trial, as concerning, and I agree that there was no outward or overt threats of violence, but given everything that I heard, and when I read the report that was prepared about you, I have concerns about your mental health. Okay. And the terms that or the position that the Crown is seeking is not, in my view, unreasonable in the circumstances. I can tell you that in many cases of this type, far more serious consequences can ensue, including jail. Okay? But that is not being sought in this instance, and it's not something that I'm prepared to even consider in your case. Okay? In my view, your risk in the community can be managed adequately through a probation order, and given your personal circumstances as well as the circumstances as I found them, I don't find it to be contrary to your best interest to impose a discharge, nor contrary to the best interest of the public. Okay? So in all of that, I am going to grant you a discharge, but to manage the risk, which is not let me put it this way, it's not as though there is no risk. You are considered low risk to reoffend. In this instance, it can be managed adequately through a probation order. I'm not going to impose a probation order that is 18 months in length. It would be 12 months in length, so slightly shorter. I think that you've been subject to supervision for a lengthy period of time, and you've demonstrated that you can comply with the most basic conditions that ensure public safety. So 12 months is appropriate in my view. Okay? So the terms of the probation order, you don't need to stand, but I will get you to stand in a moment after I finish reading this probation order. It will be a conditional discharge. I'm going to place you on probation for a period of 12 months, the terms of which are the following. 2001, you must keep the peace and be of good behavior. You must appear before the court when required to do so by the court. You must notify the court or your probation officer in advance of any change of name or address, and properly notify the court or the officer of any change in employment or occupation. So we just put that up here. 2101, you must report in person to a probation officer. Have you been reporting to the Courtney Street address for bail?
I've been seeing Jennifer in Colwood.
In Colwood, okay. What I'm going to do is have you report next door today, after which they'll direct you to where they want you to report. And then the times, okay? If you've been reporting in Colwood and that's closer to where you're living, I suspect they'll arrange for that subsequent to today, okay?
Okay.
All right, so 836 Courtney Street. The phone number will be provided, inserted by 3 p.m. today, January the 22nd, 2025. And after that, you must report as directed by your probation officer. If you're arrested, detained, or serve a jail sentence for another offense, you must report in person to your probation officer within 2 business days of your release from custody or completion of the sentence, so that your probation officer can give you the direction to report. 2106, your reporting ends when you've satisfied your probation officer that you see, completed all your counseling and treatment, or that it is not required and your officer has told you that you're no longer required to report. 2202, when first reporting to a probation officer, you must provide them with the address or location where you live and regularly sleep in your phone number if you have one. You must not change them without notifying your probation officer in advance before making the change. You must attend, participate in, and complete any intake assessment, counseling, or education program as directed by your probation officer. This may include counseling or programming for mental health, B, and C, trauma recovery. .2503 now be modified. You must attend for a psychiatric intake assessment or treatment program through Forensic Psychiatric Services as directed by your probation officer. And those are the terms that I'm imposing, and I just turn to counsel. Any other comments?
No, Your Honor, thank you.
Thank you. Mr. Gauthier, I'd like you to stand as you would, please. Do you understand the terms of the probation order that I've just read to you?
Yes.
You promise to follow them?
Yes.
Do you understand that if you fail to comply with these terms, you could be charged with an offense in addition to any other offense that may arise out of the same circumstances? And in that case, you could be taken into custody and held until the matters are dealt with by a judge. Do you understand that, sir?
Yep.
All right. In that case, Court Clerk, there's no need for a Justice of the Peace to read this order to Mr. Gauthier or take his signature. If you require a copy of the order, we can arrange for that. Do you require a copy?
Yes, please.
All right. I'll ask you to attend at the court registry a little later today, or you could get a copy from the probation office at 836 Courtney Street. Okay. I don't know where you live, but if you live outside of the Victoria area, the best suggestion I can make is after you leave this courthouse today, take a minute for this order to get entered. I shouldn't say a minute, it'll take a little bit of time for the order to get entered into our system. Walk over to 836 Courtney Street, which is just next door, and report to them. They can also provide you with a copy of the order. Okay? All right, any questions?
Yeah, what was concerning? You said that you had concerns during the trial.
Okay, I'm not explaining my order nor my decision. You can, if you wish, pursue an appeal, but my decision stands.
Oh yeah, for sure. I'm definitely going to appeal.
That concludes this matter. Thank you, Mr. Goethe.
All right, take care.